Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our Thursday community conference call held one Thursday on our conference bridge, which is where you are, and one Thursday on LinkedIn audio. Today is October 24th, 2024. I'll be going over the questions that have been posted first. Out of those, I'll be going over a couple of questions I have marked as frequently asked questions. And once I am done with those, then I will start with the other posted questions. And if time permits, I will entertain new questions. Okay. In the meantime, every time, let me just lock the conference because I have enough people already in. I will not be able to then answer everybody's questions if I'm not. Give me 1 second. So how do I lock the conference? Here we go.
The conference is now locked.
Yeah, so the conference is locked. Again, to repeat, I saw 1 or 2 people just logged in. To repeat what I just said, I'll be dealing with first the posted questions. Out of the posted questions, I will first deal with the ones that I consider to be frequently asked. I think there's a couple of them today. And each time I finish, I'll ask you if there's a follow-up question. So if your question relates to what I just talked about, feel free to ask at that point. But please don't try to artificially squeeze in your question. Wait till the end. And I will be able to answer everyone's questions who's here. Okay? And that is why I've locked the conference so that no more people can log in. That said, let's get started. And the conference is subject to the normal disclaimers that you heard when you were logging in. Let's begin with, let's see, this call is being recorded. You heard that in the disclaimers. So the first frequently asked question that was posted in the forums, forums.immigration.com, green card approval before AC21 Supplement J could be filed. And this is a very common problem. It happens all the time. So what happened was my I-485 was pending for 9 months. And I worked all these years, 4 years with my sponsoring employer. My I-140 was approved 4 months ago, and I received EAD and advanced parole as well. At the end of 8 months, I resigned from my employer to take advantage of AC21, moving to a similar position, and was on notice period. The new employer was about to file 485J when asked by USCIS. But during my last working week with my sponsoring employer, my I-485 got approved and I received my green card. Can you please advise on what kind of documentation I need? There's a little confusion here. Are you in the call? If you are, press *5 on your phone. Are you in the call? Press *5. I have a question for you. I'm not clear on one thing. So from what I can see in the posting, it looks like you were still with the old employer when your green card got approved. That's what at least it looks like. I worked all these 4 years with my sponsoring employer. I received EAD at the end of 8 months. I resigned from my employer, moving to a similar position. My new employer was ready to file 485J. During my last working week with my sponsoring employer, my I-485 got approved. So this is a common issue where your green card gets approved before you are able to file a 485J. What would I do if I were in your situation? I would make sure that I have proof that I was working with the employer when my green card was approved. I would even like to get a statement or an email from the new employer where you were headed that they were ready to file a 485J. If they actually have prepared a 485J, I would keep a copy of it and just put it in something like Amazon Glacier or some such service where long term it just stays there. In case if it ever becomes an issue during naturalization, you are able to show to the government jobs were same or similar. You should have a job description. So those are the main things that you should have. Proof that you were still working with the old sponsoring employer proof that the new employer was ready to file 485J, proof that the two jobs were same or similar. Does anybody have a follow-up question on what I just talked about? Press star 5 if you do. There isn't. Let's go on to the next frequently asked question. There weren't too many. This was about H1B grace period eligibility after second layoff and B1, B2 visa options for job search. So this is also a question that I get asked a lot. I got 60 days when I got laid off. Then I got an approval of another H1B transfer, but within 10-15 days or even before I could join, my H1B was approved, but I got laid off again. Do I have 60 days again? And the answer is yes. Each time you get an approval of an H1B, it should come with a 60-day grace period. And that approval can be a transfer, an extension. I don't remember if it is also an amendment. I would say even an amendment. So you should be able to get your 60 days that way. Okay. How easy is it to get B1, B2 for finding a job after a layoff? I have not heard of a denial of a B1, B2. Nobody has called me. So it looks like pretty much everybody is getting these B1, B2s. How easy, I do not know. There isn't a measure for it, but I think it should not be that difficult. Anybody has a follow-up question on this? Press star 5. Okay. There is one that looks like Connecticut. Let's double check. There are two follow-up questions. First one, oh darn. First one is 213, California. Let's go to California. California, go ahead. I can hear you.
Yeah, hi. So just wanted to ask if I can apply for a second B2 extension after the first one is approved. What are the chances for the second B2 extension for getting approved or rejected?
Okay, so there is let's make sure we are talking about the same thing. When you say second extension means third B1, B2.
No.
Second B1.
Second B1,
so
B2.
It's first extension.
Yeah, after 6 months.
Yeah, so first extension. Yeah, people are getting first extension so far. Okay.
Okay. So I can specify I'm here for job search and that'll be okay.
Yeah, absolutely. Always tell the truth, whatever the truth is. Okay.
Okay.
Good luck. Let's go to area code 929. Not sure where they're calling from. Go ahead. How can I help you? Area code 929.
Good afternoon, sir.
Good afternoon.
The question is, my last working day, I resigned last month, and the last working day was 6th of September.
Mm-hmm.
But there is a last pay stub, a settlement.
Okay, this is, hold on. This is not
Yeah.
really a follow-up on what I talked about. But just because this is a common question, I'll answer it anyway. H1B 60-day grace period begins on the day your pay period, full pay period ends. So let's say I was working till August 15th. Okay. But my paycheck, which came on September 1st, covered me till October 15th. It's a full paycheck. My 60 days will begin on October 16th, even though I stopped working on August 15th. Understood?
Okay, sir.
Good luck.
Thank you.
Yep. Yeah, guys, let's just stay disciplined. Just ask me follow-up questions. No new questions when I invite follow-ups. Okay, so let's go on to the rest of the posted questions. The first one is H1B is approved. Then I-140 EB3 transfer options for engineer joining partner's small firm in alternative visa category. I'm a mechanical engineer with a professional engineering license, currently working in HVAC design. I'm on H1B with an approved I-140. I have an offer to join my friend's business, and he has a green card. His company is also doing HVAC design. Okay. If I join him as a partner, okay, if you join him as a partner, you will not be able to process your perm-based green card through that company. Okay. So there is really no green card category that would be helpful to make things much faster for you. You could try an EB1 as an entrepreneur. I think it's a long shot. You can never predict what the outcome of EB1s is. The perm process, which tends to be more certain, would not be available for somebody who owns part of the company. Okay. If you have a follow-up question on this, please press *5. There's no other easy category that's going to be faster than this. Let's see, area code 216, Ohio. Ohio, go ahead. You have a question, a follow-up question?
Hi. So actually, I have one more question about like if I maintain an employer-employee relationship, not joining the business, then it should be any other way to get an early green card or something?
There are only 3 employment-based categories. One is EB1, one is EB2, and one is EB3. There are a couple of variations in these. In EB1, you have 3 flavors, EB1 A, B, and C. A is for people who are top 10% or so in their profession nationally. B is for researchers or professors. C is for intra-company transferees, people who have worked outside for a branch of the company for at least 1 year. Okay. So then comes EB2 category, in which there's the normal perm-based process and there is national interest waiver. And then comes EB3 category, which is for people who are not qualified under EB1 or EB2. There's no other employment-based category. Okay.
Yep. Thank you.
You're welcome. Okay. So next question was, let's see. This is F4 family visa adjustment of status from B2 without I-130 receipt approval notice, timeline and travel. My uncle, mother's sibling, filed for a green card petition, so mama, okay, in 2006. The date has progressed beyond priority date. So for mother, my mother is currently on a B2 visa in the US. We could proceed with adjustment. The problem is, if somebody enters the United States on a tourist visa, already having decided I'm going to convert to green card, they can create a lot of issues, including allegations of fraud. Okay. But if the circumstances are she never knew dates are going to progress, she had no intention of converting to green card within the United States. I personally avoid these kind of cases. I just do them as consular processing. To me, that makes better sense. So there is a problem. I do not know how to solve this issue. My uncle years ago lost the approval notice. He only made note of the receipt number, but lost the mail. I tried contacting USCIS, asked for a duplicate notice. I think you have to do an I-824. You don't have a choice. So you file an I-824, let mom go back, and once you get the duplicate notice, take a look at it, whether the case has been forwarded to the National Visa Center. It should have. You can also try contacting the NVC and see if they have a case. It'll have to be her who contacts, because they won't talk to you. You're not a lawyer and you're not the beneficiary. But your uncle could call. So try to contact NVC. My uncle gave me an NVC invitation letter having her case number. You know, if you already have an NVC case number, you should not need the approval notice, because that means the NVC has a duplicate file. So her file has been forwarded to the NVC. Just follow the instructions on the NVC notice. They should be asking for some additional documents. Make sure you comply with those. Okay. They give you 1 year to comply. So just contact NVC and take it from there. Good luck. Press *5 if you have a follow-up question. Anyone has a follow-up question on this? Press *5. Okay. Then the next question is, civil engineer transitioning to IT, OPT eligibility with FE certification, H1B sponsorship, NIW. That's a huge bunch of questions. I'm not sure I'm going to be answer them all, because then you also have a question about mixed nationality marriage, F1 investment options, B2 visa for family visit, F1 to B2 changes. Oh, there's no way I can cover all of these. Let me see if I can cover the most urgent ones. My major was civil engineering. I gained interest in IT. Got a course that did a master's in business analytics. I would like to know if I do a certification in civil engineering, such as clearing the FE exam, which is nationally recognized certification. Can I do first year OPT in the field? No, you can never do an OPT based upon a certification. It has to be a full-fledged degree. Also, let's say the employer in the major civil engineering is willing to sponsor H1B. Is it possible? Well, that depends. You got to get your degree and experience evaluated. If you qualify, certainly. In the event of an NIW I-140, I have this gut feeling that my proposal will be adept enough. Working on national projects, no. As a site engineer, very difficult to win an NIW like that. Because the government wants to know what is the national impact of your work. So you have local impact. Wherever you work, in that city, in that state, maybe you have some impact. Second thing, they will say you have no impact beyond your company and its clients. So that's a very tough NIW to win. If I'm Indian, I marry a Pakistani national, will I get family-based, sponsorship-based green card? How would you do that? She's not a U.S. citizen or green card holder, is it? You said she's a Pakistani national. So this question does not make sense. However, if you get married to somebody from another country, when you do an employment-based green card, your green card will be moving at the speed of her country rather than your own. That's called cross-chargeability. Can I invest in stocks or bonds and debentures as an F1 student? Well, you can always do that. You just can't do day trading, in my opinion. I'm always in a dilemma of what is major like. Say I have X course. What is considered as major versus minor? Talk to your school. They can tell you. I would like to have my mother visit in the US. What is the basis for a B2 visa application? She wants to visit her son. Can I switch from F1 to B2 and vice versa? Very doubtful. You can't keep doing that. Once or twice you might be able to. Once you might be able to do it, F1 to B2. But you can't keep converting one from the other. Okay? Star 5, if you have a follow-up question, I was able to cover most of them. Star 5. Okay, no questions. Let's go on to the next one. Impact of H1B denial due to incorrect SOC code on the new H1B. Joint an individual I-140 after marriage to a US citizen. My girlfriend got an RFE for H1B last year. Petition got denied. They submitted the wrong occupation code. If I marry her and get her here, will that H1B petition denial affect? So I'm not sure what is your status. I don't think you've mentioned that. I don't think you've mentioned that. I'm assuming you're on H1B. And if you are on H1B, you get her here on H4. Her previous denial has no issue at all because it's not fraud or anything. It's just a mistake, it appears, made by the employer. I don't think that denial has any impact on any immigration or non-immigrant visa she files. Okay. It should not have any effect on your I-140. It should not have any impact on any future I-140. If it's just a denial based upon an error made by a past employer, there should be no issue. Press star 5 if you have a follow-up question. Press star 5. Okay, we are zipping through. Just a few more questions, then we can get started on new questions. Next question is EAD renewal for I-485 applicant working in Canada. Filing requirements while living abroad on H1B. My 485 is pending, EAD is expiring. Currently in Canada, working for the same company. I commute to USA for work on H1B. Can we submit EAD renewal? You have to be inside USA when you submit the renewal. And as long as both of you have H1B visa, H4 visa, you can travel out and the EAD will be processed. Okay. So when you apply, you must be in USA, but then you can travel. Discuss the details with your lawyers, please. *5 if you have a follow-up question. Press *5. Next question. Perm labor cert continuity assessing validity post-termination. After layoff, if same company rehires me for a similar role, can I continue my previous perm or need to restart all the way from the beginning? You probably will have to restart. Okay, that would be the smart thing to do. If there's a discontinuity in the job, perm could definitely come under question even if you get an approval. So I would avoid continuing. I don't even think you can, because I don't know what stage you left at. So once you leave, you can't continue the previous perm. If it's still pending, that might be a different situation. So in that case, there might be some argument for saving it, but I doubt that's going to be a safe policy to follow. Okay. *5 if you have a follow-up question, press *5. Next question, I-485. My birth certificate has my mother's name, my father's name, as alias matching my passport. And other documents, there's original name in my birth certificate. Is there pet names? Oh, pet names, you mean like something they call you at home. Can it create issues? Or should I get non-availability of birth? See, you're not very clear in what you're asking me. I'm assuming all you're saying is there's a discrepancy in my birth certificate and my passport documents. Okay. So these discrepancies should be resolved. And most of the times you can even resolve them at the end of the green card process, or you can just do a name change through applying in the courts in the United States. It's an easy enough process. And the fact that you have an informal and a formal name can be explained to the government in any filing you make. I don't think it's a deal breaker issue. Okay. So you have several options. Discuss it with your lawyers, whatever they suggest. You have all the three options: leaving it the way it is, changing it during the 485, and changing it through the court systems. Press *5 if you have a follow-up question. Press *5. Starting a consulting firm on H1B. Currently on H1B, working with a pharma company, want to start a business. This is a question I have dealt with quite a few times. Please read our frequently asked questions. So right now it is, let me give you the bottom line. There's a regulation pending which has not been decided yet, not been finalized yet. But right now, if you had majority stock in your company, you could have an issue. If you have minority stock in a company, you probably can own the company, as well as the majority stockholder or board of directors can fire you. So there's an employer-employee relationship. Okay. *5 if you have a follow-up question, press *5. H1B stamping after RFE. During my initial OPT in 2021, I worked for a company for 1 month, not paid. The company got blacklisted. Filed my H1B last year, got an RFE. I submitted all email certificates and proved the relevance. Now I'm planning to travel to India. So here is the issue that I'm not clear about again, some things that you haven't told me about. You said you worked for 1 month. Is this a part of your service? Have you entered that company's name in your service? Or did you treat that time as unemployment? That is the main issue. But if you have mentioned that company, this issue can still come up at any stage, including visa stamping or green card or an H1B extension. So can I change my job and go to India in 1 month of changing job for stamping? Sure. There's no law that says you have to have held that particular job for a while. *5 if you have a follow-up question. Okay, last question. Concurrent H4 EAD applications. Okay, H4 EAD is pending. My H1B I-140 approved. 180 days are complete. Can my new employer file for my wife's H4EAD application while H4EAD application is still in progress from old employer? Well, H4EAD has nothing to do with your old employer. You filed that application or your wife filed that application. Can two H4EAD applications process at the same time? One from old and one from new? I think so. I don't see any problem with that. Okay. Press star 5 if you have a follow. Okay, you have a follow-up question. This is from Massachusetts. Yeah, Massachusetts, go ahead. I can hear you. Hello. Area code 978. Go ahead. Hello. Okay. Folks, anybody has any question, press star 5. Those were all the questions I had pending. So I've got 6 new questions. So let me try to go in the order you logged in. First one is Virginia. Let's find Virginia in the queue. 703. Where is 703? Here it is. 703, I just talked with you. Did you have a question? Go ahead, please.
Yes, sir. I had a follow-up. So, sir, this was regarding the H4 while the H1 was under the administrative process. You had mentioned she can do a H4 and come on a change of status.
Sure.
So I have a question there, sir. If she comes to US on a H4 and the H1 is still under pending administrative process, so if she does a change of status, would that mean the pending application will be cancelled, and if she goes to India again, she has to go for the stamping? Or is there an opportunity that is that? Yeah.
If the H1B gets approved, then she should be able to use that, because there are only 2 possibilities. H1B will be approved or denied. If it is denied, of course, when she travels, she has to go for a visa stamping. But if it is approved, she should be fine. Okay.
But will that be on the new petition or the old petition? Because she comes on
the visa stamp doesn't belong to a particular employer. A visa stamp, you could get an H1B stamped through IBM and then 3 months later change to Oracle, get an Oracle approval. You can travel with visa stamp of IBM, but H1B approval of Oracle, no problem.
So you're saying that she can come on a H4, do a change of status independent of what happens to the pending administrative process. Even if it gets denied because she did a change of status, it'll be a brand new application when she goes to visit India the next time.
So that's too many words. I'm not sure what you asked me.
Okay.
But let me tell you how it works. Okay. So the way it works is when she enters the US on an H4, is she eligible to do a change of status to H1B? Absolutely. Once she does the change of status, is she legal as long as she stays in the US? Sure. If she needs to travel, however, she will need to go apply for a visa stamp if the initial visa stamp was not approved. If the initial visa stamp was approved, she should be able to travel with that and the new approval.
Okay. So my just worry was if it was under pending application, so would it impact any new application? But you're saying that
No, it should not.
It is independent of employer.
No issue.
Okay.
All right.
Thank you so much.
Good luck.
I really appreciate what you're doing. Thank you so much.
My pleasure. My pleasure. Michigan, area code 906. Go ahead, please. Michigan. 906.
Hello, sir. Good afternoon.
Good afternoon, sir.
So, can you give an explanation for the question, last but one question again?
Which question did you ask?
H1B stamping after RFA travel considerations. Last but one question.
You have to ask me. I'm not sure what you are talking about. Is it a posted question or is it something I just talked about?
It is a posted question, sir.
What is the question number? Are you Prithvi?
Question number 12.
Question number 12. Okay, got it.
No. Yeah,
got it. Yeah, this is the blacklisted company, na?
Yes, sir.
Okay, so here what I wanted to know was this blacklisted company shown up as one of your employers in your service, or did you show as unemployed during that 1 month?
This is a like question for a friend, sir. But
So until we know that, there's not much
recently,
I can tell you.
I mean, like recently, like in the news, like there is a company,
Okay,
like
none
news
of that is
circulation, like
relevant. No, what? Stop. None of that is relevant. Only one thing is relevant. Did your friend list this company in service, or did he or
yes,
she treat it as just unemployment period? Okay.
like they listed it on service.
If she listed it in service, she can be asked about it and she should be prepared for an explanation. Okay.
Okay,
That's what is important.
thank you, sir.
The most important thing is she should not have paid them anything. Because if she paid them and tried to get a false certificate, she is in trouble. Okay. Good luck, sir.
Thank you, sir.
You're welcome. Area code 978, Massachusetts. Go ahead, please.
Yeah,
978.
Rajiv, this is Prithvi here. The last question I asked, concurrent H4 EADs. So actually, my employer had filed for the H4 EAD. Like they said that
Yeah,
they
but
would do
that
it
doesn't
on
matter. Who has filed doesn't matter. It's still your wife's application. Employer has no hold on it. Yeah.
My question is like, what if they withdraw it? Like, suppose if I leave the employer, can they have the power to withdraw the H4
They
EAD
should not be
application?
able to withdraw it.
Okay, they should not be able to do it, but
No.
they can do it still. If
Well, I mean, they actually are nobody. They can withdraw your H1, but they can't withdraw the H4.
okay, and my my H1B would be transferred, so the H4 EAD would still be in continuity. Like it wouldn't break. The
See,
application wouldn't
here
break
is the
anything.
problem. Here is the problem that I see in these cases, and I've had this happen before. What happens is when I am jumping ship, I'm going from one H1 to another. There is a possibility, let's say, you can transfer as soon as you get the receipt, right? So as soon as you get the filing receipt, you can transfer. When you do that, your H1B is pending. Her H4 EAD is pending. If the old employer revokes the H1, which they are required to, you could be in a situation where the new H1B is not approved, but the old one is revoked. I've had cases where the government said, well, because the H1B was revoked, her H4 is gone. Your H1B is no problem, but her H4 EAD is gone, which I have never understood the logic of. So here is what I suggest to people. I say do this. Either join the new employer after the H1 approval. So don't join on receipt. Wait for the new employer's H1 to be approved. Then you can give your notice and join. That way,
So then that would be like, yeah.
That way, the ship that you are jumping to is already solid for you. And if it is solid for you, it's automatically solid for your wife.
Got it. Okay.
Make sense?
That makes sense.
Yeah.
Thank you.
That's what I've been doing. Because I was shocked by the interpretation the government placed on it. You see, the problem is it is just expensive to argue with the government. So I never get into an argument if I can avoid it. We try to find ways to comply. So this is a good kind of a compromise between joining as early as you can and protecting your wife's pending case. Okay?
Makes sense. Thank you so much.
Good luck, sir. California 858, go ahead. By the way, I just have 3 more questions pending. California, go ahead.
Hi, sir. Good afternoon.
Good afternoon. Ji.
I have a good question regarding H1B transfer while being outside the country. So here's a little bit background about the story. So I worked for an employer on OPT. Then last year, my H1B got approved, and I went to India in September 2023 for H1B stamping.
Okay.
And I got stuck there for almost 8 months.
Okay.
And my visa was stamped in May of this year, May 2024. So all that time, I kept working for my employer remotely with the US pay only. From October 1st of last year, they were charging me Social Security and all those kind of taxes.
Okay.
So, but in April, so they laid me off. Okay. So after like 20, 30 days, my visa I got my visa in my hand, but I got laid off in April.
Okay.
So my question is, because I never entered the country, so is my H1B transferable? But I have already worked for that employer, but never entered the country.
Yeah, hold on. So your situation is, were you in the US at all ever?
Yes, I was in the US as F1 student, then worked for that employer on OPT.
But you never worked for that employer on H1B, right? Is that what you're saying?
So when my H1B period got started last October 2023, I was outside the country.
So you never
still working remotely.
So you never worked inside USA for that employer on H1B, right?
Yes.
But you did work for them remotely from India.
Yes.
Okay, so your situation is so weird that nobody knows the answer to these questions. But I can give you educated guesses. First of all, I would argue, and I think I'm right, that your visa is transferable. Your H1B is transferable. Okay? Number two, I would also argue that you can travel on the new transfer and the old visa. You don't need to go for a visa again.
I see.
That's what I would argue. Am I right? I guess we'll find out. Okay.
I see. So how about the entering to the country? Let's say if a new employer files for H1B,
you should not enter without approval in hand.
I see.
Okay.
So I shouldn't be entering on the SIP number.
No, sir. You should not enter without approval.
What about if my old employer, it was a consultancy, and if they find me a new project, so
they'll have to do an H1B amendment. Once you get the amendment, then you can change.
So need to wait for the approval, or just
you should wait for the approval. That's what I would recommend, because you've been laid off. Remember that? So here's the problem. Yes. See, normally when an H1B employer lays an employee off, they have to inform the government and revoke your H1B. Okay.
I see.
And they should have done that. And if they have not done that, they can do an amendment. And if they have done that, they can apply for an H1B again for you. But you should not enter without approval in either case. Okay?
I see. Okay.
Good luck.
Thanks so much.
You're welcome.
Thank you.
You're welcome. California, area code 213. Go ahead, please.
Yeah, hi, sir. I was on H1B and I got laid off during March of this year. I filed for a change of status to B2, which got approved, and the end date of that B2 is November 25 this year.
Okay.
What I'm planning is to do is to transfer to F1. I got an admit from university.
Okay.
So I want to transfer to F1. And the date of program start date on I-20 is Jan 6, 2025 next year.
Okay.
So my question is, the earliest date I can request for F1 start is 30 days before the program start date, which happens to be December 7th.
No, that's not true. That's not true. Check with your DSO. You can apply for an F1 even in November. I don't see any problem with that. But what they say is that, and I'm trying to remember the rule on this, that you will not get an approval earlier than 30 days before the start date. Okay. So that means between November and January, you would not be unlawful or illegal, but you'll have like kind of a blank period where even though you're authorized to stay, your status will kick in only 30 days before January, which is December.
Okay, so I can, let us assume I'll be filing it before November 25.
No, let's say you file it today. You file a change of status today. Can you do it? Please double check with your DSO. I remember there was a change in policy. And I think you can. Okay. What would be the start date? No earlier than 30 days before the course starts. Okay.
Okay.
But what about the period from November, December, when I have no status? Well, that's not illegal according to what I understand.
Okay. So yeah. Okay, I see that if I file it now in the next week or something, I can still stay in the US, and
I think so.
Once the approval comes, I'm legally on F1.
I think so. Okay.
Yeah. Okay. What should I ask my DSO specifically?
Just say, ask the DSO, can I apply for my change of status now and continue to stay even though my current status will expire in January? No, when will it? November. It will expire in November. Can I continue to stay until January till my course starts? And by the way, this information is there on the USCIS website also. Okay.
Yeah, I saw the website, but it was not clear. It said it doesn't say anything about. It says you have to file before your non-immigrant status expires. That's what.
Exactly, and that is B1. That's exactly what I'm saying. So your current non-immigrant status is B1 or B2, right? Yeah.
B2.
As long as you get it filed before November, you can continue to stay even though your semester starts in January.
Okay. So the in-between period should not be a problem at all.
That's what I understand. Go read that again. Talk to the DSO. If that DSO is not clear, talk to another DSO. Okay.
Yeah, sure. What in the worst case is F1 is denied, just for the sake of knowledge I'm asking, if F1 is denied,
you would have to leave the US, but I don't believe you accrue any unlawful presence.
Okay.
All right.
Got it.
Good luck.
And one more thing, I'm staying here to look for a job. As I said, I was laid off. So in the future, if I find a job, probably in the next 3-4 months after starting the course, I'll have to break my F1 and go to H1B again. So will there be a problem when I go for stamping in the future?
I don't think
citing intent to immigrate.
I don't think so. Intent to immigrate is allowed on H1B. Okay.
Okay, but I'm changing from B to F1, H1B back, all the fiasco.
Yeah, but that's all legal. You're not doing anything illegal. Yeah. You're doing everything by the book, right?
Yeah.
So, I gotta move on. Good luck.
Yeah, thank you, sir.
You're welcome. Bye-bye. Area code 903. That's Texas. Let's go to Texas. Yeah, Texas, go ahead. I can hear you.
Hello, Rajiv. Good afternoon.
Good afternoon, sir.
Yeah. I have, this is regarding the AC21. So, I have filed my 485 adjustment of status in August 2022.
Okay.
And my priority date is September 2014.
Okay.
So, this was like I have applied adjustment of status with my old employer. And I got my EAD and advance payroll. Just couple of 3 months before, in July 2024, I have accepted an offer with a new employer as part of the AC21 Act.
Okay.
I have booked my flight ticket to travel to India next month, 2024, November 2024, and planning to return to US using my advance payroll.
Okay.
So my question is, do I need to file a 485J?
Yeah, I always do. I always do. I have never taken a chance with something like this. I do not travel until I've filed my supplement J. Okay. I don't know what the rule and the policy is. I don't think it's very clear. I don't like to take chances. I can only tell you what I do. Okay.
Yeah, the only problem is like my priority date is September 2014. I mean, like it may take like 5+ years to get my green card. I'm not sure how many employers.
So you can. There is no limit to how many sub Js you can file. You can file 50 supplement Js over the next 5 years. No problem.
Okay. I mean, like this is like a gray area. I was not sure.
Well, this is the way I look at it. Okay, this is the way I look at it. You can call it gray, black, blue, whatever you want to call it. The problem is, I don't want to get into an argument with the CBP officer at the airport. Okay. For them, it is very easy to say, sir, I don't believe you're a bona fide entrant. Go back. Now, how the hell are you going to come back to US? Okay. So, what makes travel safer either you have already joined the employer and you've been working with them a few months. You can show pay stubs. Okay. Or you travel after filing Supplement J.
So I have joined in July 2024. I got
So then there is enough time.
I have the pay stubs.
Yeah, then you should be okay.
I have the pay stubs.
Yeah, then you should be okay.
I have the pay stubs.
Then you should be okay.
I have pay stubs.
You should be okay.
So I can travel without applying 485J, right?
I believe so. Yes, absolutely. 485J is not required, but having a job that is same or similar is required. But please do talk with your lawyers before you.
Job offer.
Do talk with your lawyers before you go. Okay.
Yeah. Only thing is like that 485J again. Like it's like I felt like I talked to my attorney. I would like I was hearing like two versions. They were saying like we can submit a RFE. We can submit a I-485J. I mean, like if we get an RFE, and also they were saying like that 485J is kind of a future job offer once you get your green card approved. So I mean, like
no, that's
like multiple versions.
That's incorrect. All right.
Okay.
So Supplement J can be filed as many times as you like.
Okay.
All right.
But on the counterpart, like as you said, like
sir, I have to go on to my last question.
With a new employer.
Sorry.
Okay.
What is it?
Yeah. My question was on the other side, like as you said, like if I have the offer letter and I have the pay stub with the new employer, I should be safe to travel, right?
I think so. As long as you can also prove it's same or similar job, although they don't bring up that normally at the airport. So, all right.
Okay.
Good luck.
All right. Thank you.
You're welcome.
Thank you.
Bye. Okay, I see that somebody else raised their hand as well. Let's go to... first, let me go to area code 929. Okay. Area code 929. Go ahead, please.
Good afternoon, sir.
Good afternoon.
Quick question. What are the key important points if suppose I am, having an application, H1B transfer application pending with employer A, and I file a H1B transfer to employer B within that period when I have not received the approval from the employer A.
Yeah, that's perfectly legal. That's perfectly legal. So there are two possibilities. So there are three employers involved here, right? You have employer A that you are currently working with, employer B whose transfer is pending, and employer C whose transfer you want to file, right?
Yes.
Okay. Yes. So there are two possibilities. Either you have already joined B or you have not yet joined B. Are you still with A, the first employer?
Yeah, I have joined. I have joined B. I am not with A.
Okay. So when you join B, you can certainly file for C as well while B is still pending. The only downside on this is because you have already joined B, if B's status is denied for some reason and C is approved, you'll have to go outside and come back in again.
Okay.
That's the only downside. Okay. No big deal. Okay.
Okay.
By the way, these are called bridge petitions. So when you are going from A to B to C, B is the bridge between B and C. B must be approved for you to cross over to C. Otherwise, go outside and come back. Okay?
Okay. Got it, sir.
Good luck.
Thank you, sir.
You're welcome. Okay, so last question of the day, area code 858, which is California. California, go ahead.
Hi, sir. This is the second time I'm asking this question. Again, H1B transferable, being outside the country.
Right.
So, yeah, so I hope you remember. So, if my consultancy, who haven't revoked my petition yet, haven't revoked my visa yet, so if they find me a new employer or the same employer, because it was a care representative of this company.
Look, so because they have laid you off, hold on. Because they have laid you off, they should have terminated your H1B. Because that's law requires that. If they have not terminated your H1B and that job is still open and you can prove it, you can try entering. I would not if I were you. I would want to make sure either the H1B has been refiled and approved or a transfer has been filed and approved. I would not want to enter before then.
I see.
Okay?
Either amendment or transfer.
That is correct.
Even if it's the same employee or same team.
It's not, the problem is not the same team. The problem is there are two issues here. One is if they even change the client, they should file an amendment, in my opinion. And if they change the state or more than 50 miles from an approved location, they have to file an amendment anyway.
Yes.
Okay? That's one complication. The other complication is that they laid you off. So there was a termination of the H1B, but if they did not inform USCIS, did they terminate your employment? Probably not. But they stopped paying you. Is that termination? Well, that becomes just messy and not something I would want to deal with at the airport.
I see.
Okay.
And in this condition, let's say termination.
I'm gonna give you 10 more seconds, sir. Then I have to go. But go ahead and finish what you're asking.
So if they terminate, if they, let's say, withdraw the petition, so will I be, if I find a new employer, if they withdraw the petition, and after withdrawal, if I find a new employer, so will I then, after withdrawal, will my new employer be able to transfer my petition?
That's exactly what you asked me the first time around. And I answered, nobody knows the answer, but I would argue you should be able to transfer. Because you worked on the H1B, even though you worked outside the United States. Okay?
I see.
Good luck.
Okay, sir. Thank you so much.
You're welcome.
Thank you. I appreciate it.
You're welcome, sir. Folks, I've got to run. Good talking to all of you. I'll see you next Thursday on LinkedIn. Take care, everyone. Bye-bye.